Hi, students. How are you? I hope you're doing well, getting through the semester at school and also with this COVID-19. Anyway, this is a continuation of Unit 9. It's week 16 and it's on punishment. When you look at punishment, I think you'll feel that we're very fortunate to live in the United States because other countries have punishment um, that is very brutal. Recently, I noticed two postings on my news feed uh, discussing that the country of Iran, was publicizing that they were going to be amputating the hands and feet of some individuals that had committed crimes in their country. So some countries have some very brutal punishment. When you research punishment, there are many different forms of punishment. For example, public stoning in some countries, hanging. There's all sorts of different types of hanging. There's short drop, suspension, standard, long drop. There's different types of hanging. There's also the electric chair. There's lethal injection. There is judicial caning as a type of punishment. Death by firing squad, beheading, whipping, flogging, lashing, mutilation, amputation, of course, like I mentioned, taking out an eye for an eye, literally, chemical bonding. So we're very fortunate that we live in a civilized country where we do not have those forms of punishment. Um, so regarding punishment, punishment is regulated by the Eighth Amendment to the Constitution that prohibits cruel and unusual punishment. Typically, punishment is limited to serving time in prison, serving time in jail. There's payment of fines, restitution to the victim. Those are the allowable forms of punishment under the Constitution. The Eighth Amendment also prohibits prison officials from being cruel and sadistic towards the inmates, and also it requires adequate care for inmates that are incarcerated. So, Eighth Amendment is a very important a right in the Constitution. When it comes to punishment, there are actually different philosophies of punishment. There's a philosophy referred to as retribution, that every crime demands punishment. There's another philosophy called incapacitation. That means you're just locking that person up and to prevent him from harming other people. There's a philosophy referred to as deterrence. There's a specific deterrence, which means you're deterring that person from committing future acts, criminal acts. And then there's also a general deterrence, which means that you're not only deterring a particular person, which is specific deterrence, but you're also deterring the general population from committing a criminal act. That's referred to as general deterrence. And then another philosophy is one of rehabilitation. Rehabilitation is something that I am involved with quite a bit in juvenile court. We want to turn around the lives of these kids so they can become a productive human being. But also, you see a big swing toward rehabilitation in the adult court now. There's drug court, there's veterans court, homeless court. There's there's been just a realignment of punishment in adult court, and some offenders that would have served their time in prison are serving time in county jail, and the county jail is offering many types of rehabilitative programs. So rehabilitation is, you see that not only in juvenile court, but you also see that in adult court. Now, your textbook talks about the death penalty, and I'll get to that in a moment, but I wanted to broaden up this discussion into punishment, and I want to talk to you about the procedure followed in adult court. So after a person is convicted, then there will be a sentencing hearing. The judge will read the probation report. The judge will balance the harm to society and the victim against the circumstances of the defendant. The judge so reads the probation report. The judge will hear argument from the prosecutor, also from the defense attorney. We'll listen to the victim. If the victim's present, wants to make an impact statement. And then at the end of that hearing, the judge will go ahead and impose the appropriate sentence. For those of you that want to be in probation or a probation officer, one of the duties of a probation officer is to prepare a probation report that the court will use for sentencing. So the probation report is written by the probation officer. It's not only for the judge, but it's also for the prosecutor, for the defendant, for the defense attorney, for the victim. The probation report will include the crime itself. It'll the facts of the crime. It'll include the background of the defendant, the person's social history, educational history, work history, prior criminal history, drug history. It will also include information regarding the victim, the impact of the crime on the victim, and restitution that the victim is seeking. The court will also look at aggravating factors and mitigating factors. For example, aggravating factors. Aggravating factors that the victim is especially vulnerable. For example, a very young child is especially vulnerable due to the child's age. An older person is vulnerable due to their advanced age, and sometimes developmentally disabled individuals, physically disabled, they are also vulnerable because of their nature of their disability. So that's an aggravating factor. Also, other aggravating factors include if there was a weapon used or injuries inflicted. So the court will look at all those different aggravating factors, and then the court will look at mitigating factors. For example, if the person is remorseful, if the person has no priors, if the person is young, maybe he's 18 or 19 and this is his first offense, the court would look at those as mitigating factors. And the probation officer analyzes those and then makes a recommendation to the court. So the court, the limits or the parameters of sentence in a person has to be known by the court. And the way the court knows is by looking at the substantive criminal law. Substantive criminal law means that law that defines the crime, but also sets forth the punishment for that crime. So that's very important. So the court would be, and everybody involved would be looking at the definition of the crime and the punishment, and that can be found in different codes. For example, the penal code for like murder, robbery, sexual assault crimes. Most of the crimes are in the penal code, but you do find some sprinkled throughout other codes. For example, driving under the influence or auto theft, those are in the vehicle code. Your drug offenses are in the health and safety code. So you would look up that particular violation, and that would define that violation, but it would also set forth the penalty for that crime. Generally speaking, when we talk about punishment, we're talking about three categories of crime. There's an infraction, misdemeanor, and a felony. And for an infraction, that means you cannot be sentenced to any kind of custody time. It's just the court can impose a fine. That would be like running a stop sign or speeding, for example. Misdemeanors, generally it's 6 months, maximum is 6 months, and maximum $1,000 fine. There are certain aggravated misdemeanors. That's how I refer to them, and the maximum is 1 year in custody and a fine that's 1,000 or higher. What makes a misdemeanor aggravated? It could be because of the status of the victim. For example, the victim's a child or a police officer or a domestic partner, a spouse, girlfriend. So the victim status could make that simple or minor misdemeanor more of an aggravated misdemeanor. Also, the location can make it aggravated. If it was at a school or a park, there's certain statutes that make increase the punishment for the misdemeanor. Also, again, if weapons or injuries were inflicted, it could make that misdemeanor, simple misdemeanor, an aggravated misdemeanor. When you look at a felony, there's two types of sentencing for a felony. Felony there could be a determinate sentence, which means that the court will pick a particular amount of time for that person to serve. So it's a specific number of years that the person, or months, that the person will have to serve in custody. There's also indeterminate sentencing, which means that the person will be sentenced to life with a specific minimum. For example, second degree murders of 15 to life. So that's an type of indeterminate sentence. The person's release then is determined by a board of parole hearing. So the person would have to serve a minimum amount of time, appear before a parole board. The parole board would look at that person's conduct, programming, and so forth, and then decide if that person should be released on parole. One of the first things, though, that the judge will have to determine in any sentencing is whether or not to grant probation to that person. Probation means conditional release into the community, and generally it's under the supervision of a probation department. So a person has to be eligible for probation. And there are statutes that determine the person's eligibility for probation. Those statutes are in the penal code, so you'd have to look that up. But some statutes prohibit a person from even being granted probation. For example, a murder. A person is not allowed to be placed on probation for it. There are statutes that also allow probation if there's unusual circumstances. For example, a residential burglary, you can't place a person on probation unless there's unusual circumstances. So, for example, you have a young person, first time offense, the loss is minimal, he has family support. In those types of cases, the court could theoretically find unusual circumstances and then grant probation. And then thirdly, there are statutes that will allow a person to be placed on probation. If the judge decides to grant probation, the judge will suspend the sentence. Generally, it's 3 to 5 years with terms and conditions. But if you've been following the news lately, Governor Newsom signed into law two different provisions regarding probation. One is for misdemeanors, and the general rule now, I believe, will be that the maximum time a person can be on probation for misdemeanor is a year, and for a felony, it would be 2 years. In the past, it's been longer for both. But conditions of probation include things like jail time, fine, search and seizure, gang terms, domestic violence terms, counseling, restraining orders, restitution, search and seizure I mentioned. But there's just a number of terms and conditions of probation that a person will have to obey while he or she's on probation. What happens if a person violates probation? Well, they can be arrested for it, and there would be a petition filed alleging that the person violated probation. The person would appear in court for an arraignment on the violation of probation. If the person denies that he violated probation, there would be a probation violation hearing. The prosecutor has to prove that the person violated probation by a preponderance of the evidence instead of a reasonable doubt. And if the court finds he violated probation, then the person would be sentenced. If the court concludes that he did not violate probation, the person would remain on probation for the remainder of his probation term. Once a person completes probation, then the case can be dismissed. So if the judge now he's decided not to give probation, if the person is not granted probation, then the judge will have to select and impose the appropriate term in custody. So a misdemeanor that time would be in Madera County, in our case, Madera County Jail. For a felony, it's interesting because a few years ago it changed. If it was a felony, which means the sentence is over a year, then the person would go to state prison. But that's not true anymore. Now, if you have a non-strike offense, a non-serious offense, or an offense that does not require any registration, then the person can serve that time in the county jail. And the purpose for changing that law was to reduce prison overcrowding. If it's not one of those categories, then the person will be committed to state prison. And again, it would either be that determinant sentence, which is a specific number of years, or it would be an indeterminate sentence, which would be a minimum to life, 15 to life, 25 to life. That's an indeterminate sentence. So sentencing can be very complex. I don't want to make you into an expert on sentencing, but I just want to give you an idea of how it works. There are special situations, though. For example, sex offenses are taken more serious, so a person can receive substantially more time in prison. 3 strikes, of course, so that is those cases are treated more seriously. Drug use is interesting because not too long ago, maybe a year ago, most of the possession offenses were changed from a felony or a wobbler to a straight misdemeanor. A lot of crimes actually were changed from felonies to misdemeanors, and people in the community say that has led to a lot more property type crimes, identity theft crimes, people running into stores and just stealing it, like Lululemon. And it just has created an increase in crime. Now that's anecdotally, I don't know, I haven't researched it to see if that's true, but it seems like, anecdotally that it is. But regarding drug use, for example, that type of crime, there's a lot of rehabilitation involved in that. So, for example, a person could start off on a simple possession, receiving what we call deferred entry judgment. That's where they plead guilty or no contest, and then they're placed in a program. If they violate it, then they are placed on Prop 36 type of probation, which is another program. And then if they violate that, then they can receive a suspended sentence to prison and more programming. And then ultimately, if they violate again, then they could go to jail or prison. So they're getting like 3-4 chances here to turn things around. Domestic violence is also a special category, I think. There are mandatory conditions of probation. For example, a defendant has to complete a 1-year batter's treatment program, restraining orders. Probation is mandatory. They have to pay restitution. The court could issue restraining orders. Domestic violence is taken very, very seriously, especially here in our court. I just know that I take it seriously as well, and I don't see much in juvenile court, but from time to time it does happen, even in juvenile court. Just mentioning juveniles, in the past, there were certain crimes that the district attorney had to file. They did not have a choice. They had to file directly in adult court. There are certain crimes that the DA could file directly into adult court, and these would bypass juvenile court. But about a year ago, the law changed, and all cases involving a juvenile have to be filed in juvenile court. There is a method that the district attorney can request that once it's filed in juvenile court, that the juvenile court transfer the case to adult court. If that's the case, there's a transfer hearing. The court has to consider the criminal sophistication of the defendant, the youth, the gravity of the offense, his criminal history of the offender, the number of opportunities to rehabilitate the offender, and also whether the juvenile court has sufficient time for rehabilitation. Those are the 5 factors. The court has to consider those and then make a decision to transfer. The court could deny the transfer, keep the person in juvenile court, or transfer it over to adult court, and that person would be treated just like any adult. So that's regarding juveniles. I want to just end on the death penalty. The death penalty, first of all, a person has to be eligible for the death penalty. So in California, that requires a charge of first-degree murder, and generally first-degree murder is murder that is premeditated, deliberate, killing of another human being. So it has to be first-degree murder, and then additionally there has to be a special circumstance. There's probably about 26 or so special circumstances, and you would find those listed in the penal code. So for example, special circumstances include a murder for financial gain, a prior murder, multiple murders, murder of a police officer, murder of a witness, a murder that is committed by lying in wait, murder where it's based on the race, color, religion, national origin of the victim, murder by torture, poison, a gang murder. Those are all types of special circumstances. Those circumstances have to be pled in the charging document, and they have to be proven in court. So in order to be eligible for the death penalty, the person has to be convicted of the first-degree murder, and one of those special allegations has to be true. So let me talk to you about the procedure for a death penalty. First of all, there's a trial, and it's for a death penalty case. There's 2 phases. The first phase is a guilt phase. That's to decide if the person is guilty or not guilty of murder, and also if that special circumstances is true or not true. There also may be a sanity phase if the person is pled not guilty by reason of insanity. So if the jury finds the individual guilty of first-degree murder and finds the special allegation to be true, then there will be what we call the penalty phase. The penalty phase is a phase where the jury will hear the broadest amount of information on the person's background, and then the jury will have to decide, should this person be given the death penalty or life without parole. So when you have a first-degree murder with a special circumstance, the choice is life without parole or death penalty. If it's just a straight first-degree murder, the punishment is 25 to life. So if they impose the death penalty or recommend the death penalty, it's going to be up to the judge to impose that. The judge could disregard it and instead impose life without parole. So regarding the death penalty, there are some rules that I wanted to mention to you that they're actually in your textbook. First one is that the death penalty absolutely cannot be imposed for a crime that does not involve the taking of a life. There's a case in your book, I don't have the name of it, but it was a case that the court imposed a death penalty for a person who committed a terrible crime against a child. And so the person appealed and went up to the appellate court. The appellate court said, you know, this is a horrendous crime, but we cannot give the person a death penalty. Death penalty is limited to those crimes that involve the taking of a human life. And in California, it has to be a first-degree murder. The death penalty cannot be mandatory. In other words, the law cannot provide that if you commit this crime, you automatically get the death penalty. It cannot be mandatory like that. Um, so that's why there's two phases. There's the guilt phase and then the penalty phase, and the jury has to listen to all the evidence and then make a recommendation, either life without parole or death. It cannot be made mandatory. There has to be some aggravating factors to justify the death penalty. The defendant has to be given the opportunity to present mitigating evidence, and that's pretty broad. Mitigating evidence could go back, and you'll hear stories about how the person um, called a relative to say that he had an abusive childhood, that he was abused by his parents, that he was a drug addict, he was an alcoholic, maybe he suffered PTSD while serving in the military. The defendant can put on pretty much unlimited amount of mitigating evidence for the jury to consider. The death penalty also does not apply to any person who is under 18. So a juvenile cannot receive the death penalty. And also you cannot impose a death penalty for a person that is mentally retarded or insane. Some of the biggest issues before the court on the death penalty were mental retardation, and how do you determine that? Is it an IQ test? And so there was a lot of discussion by the appellate courts about that. And I believe the current state of the law on that issue is that the court and the jury would have to consider a lot of information, not just an IQ test, but all the information that weighs on that issue of the person's mental status to determine whether or not the death penalty would be appropriate. So anyway, that concludes Unit 9. Unit 9 was on trial. That was last week, and then this week is on punishment. So trial and punishment. Unit 9, that correlates to Chapter 9 of your textbook. We'll be moving on to Chapter 10, which are constitutional rights in the government workplace. I've broken that down into the last 2 weeks of your class, and you're almost done. Hang in there. I know it's been a long road, but you've done well. I've been reading your comments, by the way. I'm very impressed. I just reach out to me if you need something. I am reading what you're posting. So anyway, that'll be it. I wish you the best. Take care, and I'll be talking to you soon. All right. Bye.